Good evening. Welcome to my stand-in talk. We had pretty terrible storms out here today, and I thought to venture out, but it was just pouring rain, and there have been floods in the area. I don't know all the damage yet. By way of medical news, Holly seems better. I keep watching her. I don't, as far as I know, have COVID yet. I did take a test at the beginning, and I cleared it. But something important did happen today, and it's framing a national debate about exactly how does our government operate. And I think the centerpiece of the argument before the D.C. Circuit Court today involving Trump and what immunity he has and whether he can be prosecuted as a matter of criminal law is the very foundation of our system, how we answer those questions. Is a man above the law? That's really what Trump argues. He can do anything. And can we confuse issues that exist at the law so that everybody understands how the system has worked and therefore why the arguments made by his counsel are frivolous? Now, his counsel is Mr. Bauer, who is formerly the Solicitor General in Missouri, and he has represented Trump in other matters. I find the way he speaks annoying, I don't think I'm being peculiar because he's Trump's lawyers. He has a very funny way of talking. And being from New York and having been clocked at speaking at a fast pace, the combination of his voice and speaking fast does not help. And then before the court today, when he argued on behalf of Trump, I thought he hoped the inability to hear him and the speed with which he spoke might get him past the tough issues. I don't believe that happened. I think the judges were what we call a hot bench, meaning they considered the issues before they got there and they had questions. Speaking for the special counsel was Mr. Pierce, and he is assigned to the corruption division in the Department of Justice. And he had a very clear spoken way about him, but I don't think he had to lift as much weight today as did Trump. Now, the issues before the court, which you may find confounding, because they're layered rich in the verbiage of lawyers in court. But I will, I think, pretty simply lay out what was at issue today when Trump had appealed to the circuit court the question of whether or not he could be prosecuted at all, whether he had immunity. And his lawyer, Bauer, and others had submitted a brief to the court. The special counsel submitted an 82-page brief in opposition. I've reviewed that. There's pretty much a summary of those arguments at the oral argument today. The oral argument started at 9:30 and it finished about 11, and it was a little shorter than the one about the gag orders that was held before. I think there was less to say, and certainly less to say that was persuasive on Trump's behalf. So those of you who wonder, bottom line, was this good or bad for us? For us being people that believe in the republic and a democracy, this was good for us. It was good for the court. Now, their decision, we'll talk about that after I talk about what the appeal was about. The position we take, the people take, is that Trump has no immunity from federal prosecution. I believe it's true even when he is in office as president and certainly after he leaves office. A second question that came up is whether or not Trump, having had an impeachment and not having been found guilty, can be prosecuted criminally afterwards, whether he's in government or out of government. And the answer to that is that he can't, but I'll get into their arguments. Now, a threshold argument at the very beginning was drawn from an amicus brief that was submitted to the court, a friend of the court brief, meaning not one of the parties, not somebody from the special counsel, not somebody from Trump. And there are rules for considering those. The principal argument this group made that was considered seriously by the court, and the court asked for opinions about it, was whether or not the court can consider anything. The threshold question that a court has in the federal system is, has there been a final decision? In a criminal case, a final decision is when you have a conviction, and then you appeal that conviction. Now, it's possible there'll be no conviction. I hope that's not the outcome. I believe that shouldn't be the outcome, but that's a possible outcome. And so the decision to make now is to defer it back to the federal court. That's the argument as a threshold about this particular amicus brief. And what they could have said is, look, we don't have a final decision yet. What we'd be saying would be hypothetical, and we don't want to get into that. Of course, Trump's lawyer argued against this. To my surprise, the government, who could have taken an easy lap here and said, yes, that's absolutely right. You have us. You don't have any authority to render what would be an opinion without facts in place that justify it before there's been a final decision. So we don't know what the court will do with that. If the court wants to do what is traditionally the case when you have what they call an interlocutory order, that is, an order before there's been a final decision, the courts usually decline to take a case in that situation. Okay, but the rest of the argument was also heard. And the argument was, can a president who has ordered an act that is criminal be prosecuted if he has not been impeached? That's the argument by Trump. And there was a round robin of questions by at least two members of the three-judge panel. And there were three judges who sat to hear this. Two of them were, if I have this right, Biden appointees. One was a Bush appointee. And you couldn't tell the difference between them in terms of their arguments. Plainly, they were very skeptical of the arguments of Trump by his counsel, Bauer. And the judges asked, so if, say, somebody was impeached for inciting to riot or something, and that person was found guilty in the impeachment, then you say they could be prosecuted. And the attorney, Bauer, did not want to answer that. And there are a couple of examples that floated by. One was, what if you, as president, told the Secret Service to assassinate a particular person, and then you ran out of office? Could you be prosecuted having not been in office and not having been impeached and not having been convicted? And that was the article, that was the hypothesis that Trump's people ran away from. Plainly, you have to be able to prosecute a president who betrays his oath of office and does it in such a fashion that defies the Constitution, the laws, the good order, etc. And you could tell that that's where the court was going. Now, the attorney for Trump also had the notion that there was, how will I say it, there was immunity because of the impeachment that was had. Two of them were had, but one was specifically about January the 6th. They could invoke that as a bar, that is, a way to prevent a prosecution. Now, there are a couple of policies that occur in criminal cases. The most obvious one is double jeopardy in the Fifth Amendment. So if you're prosecuted in one court, say it's a federal court, and you're acquitted, and then they try to prosecute you again, you can say, you cannot prosecute me again because I have already been prosecuted for this, and you can't put me in jeopardy twice, okay? If you're a legislator, there's something similar, which is a kind of immunity, and it's the debate clause that they can invoke as the words that are necessary to doing their work on the Hill, say. And there's been a lot of litigation about that. Trump has come up with a new version, and his is the impeachment judgment rule. And that's where he gets the idea that I think is foolish and not very substantial, that because Trump was not convicted of impeachment, that he was therefore protected by a form of double jeopardy that applies because of the impeachment, and so he cannot be prosecuted criminally. Now, I've gone over this in a couple of walk and talks, but the short answer is these are two different kinds of remedies. The remedy of removal from office is a civil remedy and does not invoke the prosecutorial powers that could end somebody up in custody and a variety of other powers that do not apply to simply removing someone, impeaching someone, removing them from office. So that's another reason why that dog don't hunt. So that's our problem about double jeopardy. Now there's an additional thing you may have heard, which is that if one is prosecuted by a state for if one's prosecuted by the federal government for something, and then a state tries to prosecute for the same crime, since they're two different sovereigns, that is permissible. Now, a lot of states don't think that's fair. New York has a code. There are codes across America. And they have created a kind of statutory double jeopardy, that if it's exactly the same crime, same offenses and everything, that you really only have to worry about once being prosecuted. I had a case in Virginia years ago, and myself and co-counsel for different clients, we all moved the court to dismiss the case because they were prosecuting the same thing the feds were prosecuting, invoking a law in Virginia. And the General Assembly in Virginia changed the law. Talk about showing some bias. Now, another thing that one should keep in mind about this question of can impeachment have any effect on the criminal case? You may remember when Trump was being prosecuted in the impeachment matter, and some people voted for impeachment, but not enough to convict him. We had Senator Mitchell say, as one of the jurors, if you will, after the fact, why he did not vote for impeachment. And he said, that's what we have the criminal remedy for it. That is, we can prosecute someone for what they did instead of impeaching them. Now, he could have also said, in addition to impeaching them, because they have two different objectives. And so I hope I've outlined this simple enough. I think it is this simple. It may be simpler than I've made it, and I apologize if I've done that. But basically, the arguments that you have a perfect immunity for whatever you do as president, that's nonsense. The notion that you have to be impeached before you can be prosecuted in a criminal case is nonsense. The notion that an impeachment bars a prosecution criminally under some crazy rule, that it parallels the Fifth Amendment, and the Fifth Amendment's been upheld, but this version, this imaginative or not so imaginative version by Bauer, just doesn't work so much. Now, the next question is, what happens after this? And I suspect that we will have a decision in the D.C. Circuit Court in the next week or two. One of the reasons I think that is very clearly the three judges had this material down cold. And I've appeared before circuit courts myself. And if they let you talk, it means maybe they haven't read the matter, or they don't want to embarrass you because they're going to not go your way. In this case, they gave very clear signals, and I think they did that in part for the parties because America was watching as well, and because this is so important to the nation that we understand these basic principles. The citation of cases by Bauer may have been too quick and so forth to follow, but I think that the presentation by Pierce, who was the counsel for Jack Smith's office, I think that he spoke clearly enough to underscore what the panel was saying. He said one thing that I disagree with, but this is more about tactics and a decision, and it goes like this. If you can dismiss a case by saying you're bringing it too early, the interlocutory order that I mentioned at the beginning, that they have brought it before there's a final decision in the case, before there's a conviction in the case, because if there's no conviction, there will be no appeal. But that's the kind of argument. So then any decision you make now is hypothetical and can be mischievous. So there are different schools of thought. Now, some prosecutors would and I would probably be among them. And I'm not persuaded to do otherwise in this case if somebody were to ask me, and as I'm presenting it to you now. But my view is kind of similar to what the court's view is. The court's view is make any decision as narrow as possible, grabbing tightly and holding to the facts and the law that applies. In that circumstance, to say we don't have a final order, and anything we say may be hypothetical, and we have some power to do that, to make a hypothetical decision, and they didn't say what they were going to do. Now, Pierce said to them that they could have done exactly what I'm saying, but there will be very serious issues, and they wanted to resolve them now. It's not a frivolous path, but I only think it maybe is more risky to open up a discussion now, particularly when time matters. Nevertheless, I think that the circuit court will take a week or 2 weeks and we'll have a decision. Then the question is, where will Trump go? He could make a motion for what they call a rehearing en banc, which means there are 3 judges that heard it. There are more judges in the court. Bring them all into the room and see what you get. More often, that kind of action occurs when there's a dissent of some sort, like one of the judges of the 3 says, I'm a little concerned about this. I don't think we're going to have a minority or dissenting opinion of the 3-judge panel, so I don't think they'll have that. And I think Trump would prefer to go to the court that he thinks he owns. And that's of concern because we think that that's true. Now, what could the Supreme Court do? The Supreme Court could uphold what the Circuit Court does, and we don't know what that is yet. And if the Circuit Court were to do something as simple as saying, well, this is premature. It's an interlocutory order. There hasn't been a final decision in the lower court. If the Supreme Court did that, they might get the whole Supreme Court to agree to it, so they're kicking the can down the road. Now, there are a host of other possibilities, and I don't think we need to go through those. The Supreme Court is presently, according to a poll I read in the last couple of days, at something like 25%, the lowest in, it may be 40 years. It was a long period of time. And Roberts is on one hand concerned about people trusting the court, and Breyer, who was a great member of that court, often spoke to the fact that the court was only as strong and could only be followed as much as the people trusted them. So that may be Roberts' concern about his legacy. But he also has those other 5 members of the court that if they don't agree with him, it's 6-3. So, and sometimes the Chief Justice will go with those he doesn't exactly agree with because he has to be on that side in order to assign the opinion to himself or to someone else. That does not discourage other members of the court from writing dissenting opinions. Now, listening to myself talk, this sounds pretty complicated maybe, but I have been in the courts up to the Supreme Court. I haven't made an argument before them. I have filed papers there. Some have been granted, some have been denied, but none of them resulted in arguments. So I cannot argue what it's like to put on proper attire and appear before the court. I am a member of the Supreme Court. And I have appeared before the D.C. Circuit, not before the judges who are there presently, although I have 2 cases pending in that court now, and one of them is an appeal from Judge Chutkan in a criminal case. So that's about as fair a summary as I can give you. Depending on the weather, I'll be out again tomorrow. And I know some people had asked me what I thought about it, and not everybody talks about it the way I do. And I think I described some things in a way that you may not have heard others say, because they may not see it this way. I'm not saying that they see it and they ignore it. They just don't see it that way. I think this is a critical decision. I think we'll be pleased however the Circuit Court goes. The Supreme Court, I think we're on notice that we don't have the trust, and for good reason, in that court. So we can't know what they're going to do. But the way the D.C. Circuit handled itself, the way the arguments are, and the fact that they have to consider the Colorado decision barring Trump from being on the ballot. This raises the bar pretty high. So we wait and see what happens. So thank you for listening. I went on a little long. I tried to do that as short as I hope to make myself so that you could get something like my view of it without having spent 50 years at the law. So good evening. Hope to see you on the trail tomorrow.